Leader Dr. Minnis and Deputy Leader Mrs. Loretta Butler-Turner, members of the Council of the Pre-National Movement, my dear friends, I see so many of you here, and other visitors or invitees. It is my delight, really, to be the voice tonight. I'm going to present a PowerPoint that has been prepared by Commander Commander Lauren Klein, one of the members of our group who is not able to be here tonight. And he is a constitutional lawyer par excellence. He really is the backbone of a lot of our discussions, a young man who takes great pride in his own scan of knowledge. So I apologize for anything I fail to put forth as well as he would, but I'll do my best. And before I begin, I'd like to also say to you how very delighted I am that Mrs. Teresa Moxie Ingram has agreed to join me and, in fact, the entire team in our educational efforts as we move forward, hopefully. I think that's a very, very gracious move, and I can only tell you that it enlarges my job so much. She brings talents that we would never have been able to expound in the way that she does. And so I can only say it's a blessing, and thank you so much, Mrs. Moxie Ingram. And now if we would begin, please. We're going to have, as it were, an overview of the legislation, and then we'll go through the actual 4 bills themselves. I'd like to move, first of all, let's see what we're looking at. What is the overview? We'll be looking at the purpose and objectives of this legislation, give you a little bit of a background. We'll talk about what is the process for a constitutional amendment, and also some of the legal and jurisprudential issues that we feel arise, and you will already have debated some of them, as we look at the various sections that are being considered for reform. And then we'll look at the actual bills themselves, 4 of them. Bill number 1 deals with Articles 8 and 9, Bill number 2, Article 10, Bill number 3 deals with Article 14, and Bill number 4 with Article 26. Do you all have a copy of this PowerPoint? If not, I know that a copy can be made available. So don't feel that you will be left. It may not be tonight, but we can always make them available for you. Purpose and objectives. First of all, to provide background information on the process for constitutional change. Now, I dare say I may be preaching to the converted, because many of you here present are, as it were, veterans in the field of our Constitution and even in this whole process of reform. So forgive me if I go through a few of the steps which perhaps you know like the back of your hand. However, there is for us who are going to teach a very important step. We must educate our people. When I say educate, bring them on board, allow them to feel a part of the process in that they begin to understand what the Constitution is, and if it needs change, how is it changed? And so we'll provide that background, and we're going to also give a brief overview of some of the issues that drive the need for attaining what would be called by some gender equality. We want to introduce and explain the 4 constitutional bills in advance of the parliamentary debate, and that's true. We really are honored that you would have us tonight, because we hope that you will now be prepared to listen fully to the debate as it proceeds. Others that we'll be addressing will already have heard some of the speakers, but you're going to have that opportunity, and to provide, I hope, some context and information that will help in the framing of that debate. We want to discuss and obtain preliminary feedback from you. This is not a one-way street of a lecture without having real feedback. I don't know if you have in your pouches a little note from me in which I say the dialogue is just beginning. We want you to continue that with us. Give us your feedback. and give it on any of the legal or other issues that you feel might arise. I'd like you to suggest some of the questions that you feel we should perhaps provide answers for as we go out into the field, so that they will be easily and more easily understood. So the background. The Bahamas remains one of a handful of Western countries whose constitutional law still enshrines or permits gender inequality and discrimination against women. What do we mean by that? It's very interesting, you know, that probably about 5 countries in the world, maybe a little bit more, and most of them are Muslim countries, are the only countries that still maintain or hold in their constitutions gender inequality. Now that's not a point of pride. And so we really need to look at ourselves and say, well, what is it that we need to do? Do we want to remain there? Fair enough. Because if we do as a people, we can make up our own minds. But is that where we want to be in this 21st century? I'm going to move to the third bullet. Both constitutional review commissions, the Adderley-Tynes Commission and the McQueenie Commission in 2012, have recommended the government take steps to correct these legislative and social inequities. We tried in 2002, and heavenly knows you tried, you particularly, and now we're giving it another try. And so we want to make sure, if at all possible, that this time we succeed. In addition to the commissions here in the Bahamas, we've also had international human rights bodies that have made similar recommendations. So we're not making this up on our own here in the Bahamas or finding something to do. This is something that also has a resonance throughout the international arena. The amended bills, or the amending bills, were tabled in the House of Assembly on Wednesday, the 23rd of July, 2014. And the date for the referendum was announced as the 6th of November 2014. The tabling of the bills at that time was an extremely momentous occasion, and I was there. I was happy to say I was there, because I saw real bipartisanship in the presentation of the communication by the Honorable Prime Minister Perry Christie and the presentation by your leader, Dr. Minnis. Dr. Hewitt Minnis's presentation is excellent, by far. I'm not saying it because I'm in front of you. You really have to read it. And I hope, again, if you have a package, we have enclosed that in your package. I hope you'll read it once again. The language is fine, elegant, and truly fitting of this process. I want to move now to page 6 of the presentation called Process for Constitutional Amendment. And I'm sorry, because this is probably very small for some of you who are sitting there, but as I read, you may be able to pick up some of it. Article 54 provides the manner in which the Constitution may be amended. 1, by special parliamentary majorities, and 2, by approval in a referendum. Our Constitution, being one that's modeled, as so many people know, on the Westminster model of Constitution, does something very unique. It not only gives us the provisions that are similar to Westminster's model, but it does another thing. It entrenches some of them, and you hear this word entrenchment. It makes some of them so solidly a part of the law, the supreme law of the land, that Parliament itself alone cannot change it. And this is the beauty of the democracy that we live in. What is said is that Parliament begins the process, tabling the bills, but then the real power shifts to you and me, back to the people, so that this fundamental document called our Constitution is never left in the hands of the legislature alone. I think that is one of the most humane concepts I can think of in its enshrinement of true democracy and the participation of every single one of us. So in that sense, when we hear of the referendum being entrenched, we realize that every vote counts. And that's going to be our message to each individual, no matter where they are. They can be high or low or short or tall. Their vote counts, and the Constitution recognizes that. And so this is one of the aspects of Article 54. The articles that we are being faced with are altered by special entrenchment. That is, they require a deep and a larger majority. That is, 3/4 of those voting in present and voting, actually. In fact, not just present and voting, those in the House, of both the House of Assembly and the Senate, 3/4 of that must vote in favor of the bill. Now, in terms of numbers, you might write this down, because as we go along, you'll see what I mean. In numeric terms, this translates to 29 of 38 members must vote for the bill in the House of Assembly, and 12 of 16 members must vote for the bill in the Senate. That is the deepest entrenchment that the Constitution has. The slightly lighter, it isn't light at all, one is one of 2/3. 2/3 is much less in terms of its requirement of the numbers voting. This is the highest and heaviest. 29 of the 38 members must vote for the bills as they go through the House, and 12 of 16 must vote for the bills as they go through the Senate. The current composition of the House is 30 members for the government and 7 members for the opposition. No, is it 8? I'm sorry. 8. I stand corrected, 8. And for the Senate, the division is 9-4-3, representing government, opposition, and what we call floating. Is that right, ma'am? In the Senate? Yes. All right, thank you. Just want to make sure. You're keeping me on my toes and keep you on yours. All right. So we go a little bit further. Additionally, there is approval of the bills is required by a majority of the Bahamian electorate voting in a referendum. That's Article 54(3)(d)(2). Now, a majority simply means a simple majority, so that if there are 2,002 persons voting in the referendum, then 1/2 + 1, a majority of that number will carry the vote and the referendum. That's why one vote counts. By one, a vote can then carry the referendum for the people. All right, I think it's important, therefore, to stress that a constitutional referendum is part of the legislative process, and it is binding on the legislature. Those two parts are very important, because a lot of talk and a lot of consideration and debate has gone on about what is binding in some types of referendum. Constitutional referenda, binding. Once they pass that majority and the referendum says, we approve this bill, that law is binding on the country and becomes a part of the law of the Constitution. And that's a very important aspect of it. This is not just a test of your opinion. This is a real stroke of the pen that changes the landscape completely. So what are some of the legal and jurisprudential issues that arise? There is, of course, the principle of equality and non-discrimination. They have emerged as fundamental norms in most Western national legal systems and in international law. The Bahamas, as you are well aware, is party to several international conventions, which requires it to either embody the principle of equality of the sexes or to reflect the principle of non-discrimination in the Constitution and national laws. By that we mean that, as you know, the United Nations Charter or all of the United Nations conventions are usually conventions that are signed on by the various members of the United Nations. And they are considered to embody these principles in a way in which all of the other members are asked, in fact required if you sign on to them, to see that they become embodied in your own constitution. Now you can reserve against them, and we could always talk about that, but it's normal that this is a step that any person or any country that joins or is a part of the United Nations expects to have that hand put on them, as it were. There is a convention on the elimination of all forms of discrimination against women. We call it CEDAW. And in Article 2 of CEDAW, it speaks specifically to the equality of men and women. It says, states parties condemn discrimination against women in all its forms and agree to pursue by all appropriate means and without delay a policy of eliminating discrimination against women, and to this end they undertake A, to embody the principle of the equality of men and women in their national constitutions or other appropriate legislation, if not yet incorporated therein, and to ensure through law and other appropriate means the practical realization of this principle. There are reservations that the Bahamas made, of course, when they signed CEDAW, because our Constitution at that time, and still does, not enshrine that principle. And so we had to reserve. But of course, if we do move to amend the Constitution in such a way that there is established equality of men and women, then that reservation is removed, and we stand among all other countries as having complied with the terms of our signing of that convention. There's another convention that Mr. Klein referred to here, and it's called the International Covenant of Civil and Political Rights, ICCPR, Article 26 of which says, all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. In this regard, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any ground, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. It's very specific, and it speaks to the fact that all countries signing that particular convention undertake to see that their constitutions uphold such principles. There is also, not just relating to adults, there is the Convention on the Rights of the Child. And the CRC in Article 2 says there should be no discrimination between men and women in their capacity to transmit their nationality to their children. A child has a right to acquire a nationality. So there we're looking at the rights from the standpoint of the children. And we signed on to the CRC, the Convention on the Rights of the Child as well. And so we said we were going to seek to bring that into effect. The Bahamas ratified CEDAW in 1993 and entered far-reaching reservations, notably to Article 2, which I mentioned, which are arguably incompatible with the object and purpose of the convention. In other words, you heard what the convention says, and obviously our particular constitution at the present stage is incompatible with all of those terms, but we did sign the reservation. It remains one of only a handful of states, we've said, in the world which still maintains reservations to the core provisions of CEDAW, and all of the others are mainly Muslim countries with Sharia law. In 2012, the CEDAW committee recommended that the Bahamas amend Article 26 of the Constitution to bring it in line with 2A of the Convention, and that it withdraw its reservations. That is a recommendation that was made by the United Nations Committee of CEDAW. No reservation was entered into to Article 26 of the ICCPR in 2008. But there is a requirement there for the domestic laws to conform with international law. I want to emphasize that we have done all that we can, many of us, in bringing pressure to bear, as it were, to see that these changes happen, but there's still more to be done. There's still more land, as it were, to be possessed. If we could turn to the bird's eye view of the bills now, and I must move on with our business tonight. 4 bills. They're designed to accomplish separate but interrelated objectives. Bills 1 and 3 are designed to amend or replace specific citizenship provisions, which treat men differently and more favorably than women in their ability to acquire and transmit citizenship. So Bills 1 through 3, we'll look through those and we'll see how they, in some way, treat men differently. And remember, discrimination is anything that treats one group differently from another. And the fourth bill, seeks to enshrine the principle of gender equality as a substantive principle of constitutional law by adding sex to the ground of non-discrimination in Article 26. And I will refer you, when I get there, to Article 15, which seeks to establish the rights, as it were, to protection of the right to have gender equality. And therefore, Article 26 follows on just very naturally. And you will challenge me, but I hope I can show you what I mean. The scheme of proposed amendments contemplates 4 bills, giving rise to discrete issues, although interconnected, to which the electorate can give yes or no answers. One immediate question, and you may have it already in the top of your head, is why 4 bills? The draftsmen have decided, or one has decided, that as you read Article 54 and its requirements for amendment of the Constitution, the section reads quite specifically that in order to amend Section 2 or Section 8 or Section 10, a bill must be presented to the House. In other words, and then that bill will effect the change. And so it was decided that to be quite correct in reading or interpreting that section, Article 54, each bill is designed to correct a specific segment. And that is why we have 4. Each bill relates to a specific section of the Constitution, not one bill in which you have all 4 sections put in. Simplistic, but you may or may not agree. That is the best advice that we felt we were being given. Now the next frame is going to take us actually into these articles. And what we've done, which I think is very good, because when you read it, it's going to help you see where the disparity arises, where the discrimination or the inequality arises, and then what the proposed amendment seeks to effect. First of all, Bill number 1, Article 8. On the left, we give the current Article 8, and it reads as follows. A person born outside the Bahamas after 9th July 1973 shall become a citizen of the Bahamas at the date of his birth, if at that date his father is a citizen of the Bahamas. Otherwise than by virtue of this article or Article 3.2 of this Constitution. Highlighting here and keeping in your mind that anything that seeks to treat differently one group of people from the other is discriminatory. This appears to everyone on its face, ex facie, to be discriminatory because it gives only the father of the child born outside the Bahamas the right to grant citizenship to that child. The proposed amendment or replacement. On the right-hand side, a person born outside the Bahamas shall become a citizen at the date of his birth, if at that date his father or mother is a citizen of the Bahamas, otherwise than by virtue of this article, Article 3.2, or Article 10 of the Constitution. And as a result, when we look at Article 9, we'll see that we don't then need to follow through with the provisions of Article 9, if you accept that proposed replacement. 2 simple words, and yet they mean a world of difference to the social justice of the fabric of our society. 2 simple words, or mother. I won't say more. Let's move on. The commentary that Mr. Klein has, you'll find that the proposed amendment amends Article 8 to provide for a Bahamian woman married to a foreign man to transmit citizenship to the child born overseas as provided for under the current Article 8 in respect of a Bahamian man, and subject to the same limitations. So it's simply giving the female, Bahamian female, the same right to transmit the citizenship, her citizenship, to her child as the Bahamian male has. Limitations are to ensure that the right to transmit citizenship overseas in respect of a Bahamian man and now woman is restricted basically, and then we use a word which I think we may have a little discussion on. Here, Klein says native born. We'll talk about that, okay? But it restricts it to those who are native born Bahamians. The right does not arise where the person acquired Bahamian citizenship by marriage. And so I've heard a little bit of debate about that already, but that is one of the limitations that are already in place, and we would say that it applies simultaneously to the woman. The amendment of Article 8 to give a Bahamian woman married to a foreign man the right to transmit citizenship to her children born overseas renders Article 9 otiose, without validity, doesn't need to be there, it's repetitive. Hence, it is repealed. That article currently provides for children born in such circumstances to apply at 18 and before attaining 21 years. And we have some discussion points which I'll mention, but again, feel free at the end of this to bring them up. Let's talk about it. The proposed movement. Now, I want to ask Mr. Chair, is there still a movement in this regard? All right. A movement is a proposed amendment even to the bill that's been tabled. There's a proposed movement to the bill to insert an operative clause in the proposed amendment to make it clear that the right under the new Article 8 is prospective only. 8.1 will read, a person born outside the Bahamas after the coming into operation of this paragraph shall become a citizen. A very quick little bit of information that I hope you won't mind me saying, prospective, retrospective. Prospective, it looks forward only. You start from the date of the change, which would be November 2014, and therefore it will apply only to children born outside the Bahamas after that date. Retrospective means that you then give this right to people backwards. Now, there's always a choice in going backwards, that you go back for a certain number of years, or you go back to the actual date of the 1970s as opposed to the value or a little bit of problems that may arise with retrospective. All right? So we have those two words to deal with, and perhaps that amendment may give us some challenge for us to consider. Proposed movement is also there to insert a proviso preserving existing rights. So there's an amendment on the table that paragraph 1 shall not affect the right of any person who, before the commencement of that paragraph, was entitled to Bahamian citizenship by virtue of any provision of this Constitution in force before that date. And so again, we're trying to make sure in these amendments that are now being proposed even to the bills, that we don't take away from persons rights which they already have. A right is a very, very precious and a very fragile thing. It may seem easy to give, but it's extremely precarious, and judges particularly will look cautiously at any attempt to take it back or remove it. And so that is one of the essences of that particular amendment. Anyone who has it now will not lose it. Can I move on to look at, I have it as page 13, and I think it's really just a repeat of the Bill number 1, Article 10, 8.1, a person born outside the Bahamas after the coming into operation of this paragraph shall become a citizen at the date of his birth, if at that date his father or mother is a citizen of the Bahamas, otherwise than by virtue of this article, Article 3, or Article 10 of the Constitution. Paragraph 1 shall not affect the right of any person who, before the commencement of that paragraph, was entitled to Bahamian citizenship by virtue of any provision of this Constitution in force before that date. So that would be the composite version if the movements were also included. Let's move to bill number 2. And here you will see that this deals with Article 10. The current Article 10 says any woman who after the 9th of July 1973 marries a person who is or becomes a citizen of the Bahamas shall be entitled, provided she is still so married, upon making application in such manner as may be prescribed, and upon taking the oath of allegiance or such declaration as may be prescribed, to be registered as a citizen of the Bahamas. Provided that the right to be registered as a citizen of the Bahamas under this article shall be subject to such exceptions or qualifications as may be prescribed in the interests of national security or public policy. But Article 10 deals with any woman. Note that it deals with those persons who, married to a person who is a Bahamian citizen, has a special right. Here again, the woman, the foreign woman married to a Bahamian man is treated differently. I'm not saying it's wrong, I'm just saying it's different. And differently means there is a discrimination in effect. And so it is sought in the proposed amendment to have the amendment read: any man or woman who marries a person who is or becomes a citizen of the Bahamas shall, subject to paragraph 2 and any other prescribed conditions, be entitled, upon making application in such manner as may be prescribed and upon taking the oath of allegiance and such declaration as may be prescribed, to be registered as a citizen of the Bahamas. But then we go on with a second paragraph, which will try to deal with marriages of convenience. And I must tell you that this particular topic has engaged many other countries. And we've had an exploration of a number of other constitutions and how they deal with it. And so we might have a little discussion on that, particularly constitutions in the Caribbean, although we usually look at constitutions even wider and throughout the Commonwealth. In this particular 2, it says a person may be denied registration. That is the man or woman who marries a person who is a Bahamian citizen. This registration may be denied under this article if A, there is satisfactory evidence that 1, the marriage no longer subsists. 2, the marriage was entered into for the purpose of enabling that person to acquire citizenship of the Bahamas. Or 3, the parties to the marriage have no intention of permanently cohabiting with each other as spouses after marriage. And then B, the person has been convicted in any country of an indictable criminal offense involving moral turpitude. I think we'll have fun discussing what moral turpitude is, but it almost sounds as bad as it is. And paragraph 2, shall not affect the right of any person who, before the date of commencement of that paragraph, was entitled to apply for citizenship of the Bahamas by virtue of any provision of this Constitution in force before that date. A saving clause that if you had the right, you're still going to have that right. The commentary on page 15, this particular amendment amends Article 10 to provide for a Bahamian woman to have the same right to transmit her citizenship to a foreign spouse, as now enjoyed by a Bahamian man under the current article. There is a proviso added to guard against marriages of convenience, and it lists specific circumstances or conditions on which registration may be denied, including conviction for criminal offenses that would normally disqualify a person from attaining citizenship under those laws. And so we have some discussion points, and there is a proposed movement to this bill. 1, to reinsert the requirement of a subsisting marriage and an operative clause as follows, and this is the way it would read. Any man or woman who, after the coming into operation of this provision, marries a person who is or becomes a citizen of the Bahamas shall be entitled, provided he or she is still so married, upon making, and you go along with the other rest. And we want to, it's suggested in the movement that we reinsert the national security and public policy exceptions, except for national policy or public security grounds, or making sure that those particular conditions have been satisfied. In other words, you can deny the registration on such grounds. Then the third point in the movement is that we delete the qualifier indictable offense involving moral turpitude. There is a discussion that really we need to remove those words from subsection 10 to B and replace them with B. The person has been convicted in any country of a criminal offense specified in any law which makes provision for such denial on the ground of such conviction, without going to the question of the moral turpitude. So the composite version, when you see the composite version, this is what the bill would look like with the combined movements and the amendments that I've mentioned. And that, for Article 10, is mentioned on page 16. If you don't mind, I won't read that. If you mind, if I just go ahead, so that we move on to bill number 3. All right? If you have it, you can read the composite version. Bill number 3 deals with Article 14. Here we have a reference in Article 14 to children who are born out of wedlock. And it says this: any reference in this chapter to the father of a person born out of wedlock, other than a person legitimated before 10th July 1973, shall be construed as a reference to the mother of that person. And again, forgive me if I appear to sound teacher-like, okay? There is in English law, English common law, a principle called the principle of the filius nullius. Filius nullius means the child of no one. I really put it as the child of no man. And many of you may have heard me speak about this, because you see, in English society, the question of inheritance is extremely important, especially for property or the baronetcy, the title, whatever it is. You need to have certainty, and you need to know who is really going to inherit this title. And so this law, called the law of male primogeniture, I'm going to tell you what that means in a minute, arose because it said that the oldest lawful child, the oldest lawful male child, was the heir at law. Now that had to be the oldest child born in marriage, the oldest male child born in marriage. Therefore, that male child had a father. His father was the father of the marriage, was the husband of the marriage. But where a child is born outside a marriage, that child had no father and continued to have no father. It certainly had a mother, but it had no father, because if you had a father, you had a right of inheritance. Where you have no father, there was no right of inheritance. And so the filius nullius was the child of no man, the child of no one, and therefore there was no entitlement. That was a child born out of wedlock. I'm saying it in a little bit of a colloquial way. I'm not trying to tell you that is what everyone would say, but that's how my students understand it. And it's a fairly easy way to look at it, because it puts that child at a great disadvantage. The child has no father, but also the father has no right to the child. Eventually, really, the child was the child of the state. And women's rights started at about the end of the 18th, 19th century to be very active, and said now even the woman needs to have a right to this child, because usually fathers had the entire right to their children, sole custody rights. So the women started to agitate. We want to have equal rights with the fathers of our children. But of course, there were those born out of wedlock. And so as a result, the woman became the one person who had, as it were, the right to that child. So a child born out of wedlock had no father, but always took from its mother, particularly citizenship. It got the right to citizenship and the citizenship it received was the citizenship of its mother. I hope I'm not confusing you, but I'm just trying to make that clear. So here we have in Article 14 that wherever there is a reference in the Constitution to a person born out of wedlock other than a person legitimated. A person legitimated means a person who's born out of wedlock but whose mother and father marry subsequent to their birth. But there must be the mother, natural mother, and the natural father of that person. Now, that person may be 5 years old when their parents actually marry. But as of the date of their marriage, that person is 1 day old because he's become legitimated, and that was done by statute. So, other than that happening, you shall construe the reference always when it says father to the mother. The mother had the rights of the child and to grant the child citizenship rather than the father. And so subsection 3 went on, any reference in this chapter to the national status of the father or a person at the time of that person's birth shall, in relation to a person born after the death of the father, be construed as a reference to the national status of the father at the time of the father's death, or where that death occurred before 10th July 1973, and the birth occurred after 9th July 1973, the national status that the father would have had if he had died on 10th July 1973 shall be deemed to be his national status at the time of his death. So you have to construe anything there as really it being a reference to the mother of that person. The proposed amendment. Article 14 is amended in the following manner. By the deletion of paragraph 1 and the substitution, therefore, of the following. Father, in relation to a child born out of wedlock, means a person who is proved in a manner recognized in law to be the father of that child. And B, by the replacement by paragraph 3, by the replacement of paragraph 3 by the following. Any reference in this chapter to the national status of the parent of a person at the time of that person's birth shall, in relation to a person born after the death of his parent, be construed as a reference to the national status of the parent at the time of the parent's death. And so we're giving an actual time frame in which you can ascertain the nationality of the person because of the death date of that father. Commentary. This amends Article 14 to allow a Bahamian man to transmit his citizenship to a child born out of wedlock, something that was not possible, is not possible to this day, subject to proof of paternity. It removes what we call the constitutionalization of the filius nullius rule. In essence, filius nullius, inequitable as it is enshrined in our Constitution. I have to pause. This hopefully will remove it. The reference to proof of paternity in any manner recognized in law is a reference to the Status of Children Act, which already provides for circumstances in which paternity is presumed for the purposes of Bahamian law. The Act currently does not apply to citizenship relations at present. A suitable amendment agreeable to both sides will have to be proposed to define the test circumstances in which it will apply to citizenship relationships. And we know that nowadays there are very scientific tests that can be given. The DNA, blood tests, but DNA definitely gives us proof beyond any doubt, almost 100%. However, a court of law is usually also involved in the grant of a certificate of paternity. We'll note in the last bullet says that it replaces father in 14.3 with the word parent for gender neutrality. And so we have the current, we're moving to bill number 4. I'm on page 19. Yes. Article 26 currently says, in this article, the expression discriminatory means affording different treatment to different persons attributable wholly or mainly to their respective descriptions by race, place of origin, political opinions, color, or creed, whereby persons of one such description are subjected to disabilities or restrictions to which persons of another such description are not made subject, or are accorded privileges or advantages which are not accorded to persons of another such description. I'm looking at the operator booth. Are you with me? Is it at all possible to switch to Article 15? No? I would like, just before we go to the proposed amendment, I want you to look at Article 15 of the Constitution, 1.5. We just looked at, and those of you who have a copy, you have a copy of Article 26.3. All right. Article 15 of the Constitution is what we call the protection of fundamental rights and freedoms of the individual. And I want you to note a series of words here. Because it says, whereas every person in the Bahamas is entitled to the fundamental rights and freedoms of the individual. Every person has these fundamental rights. That is to say, has the right, whatever his race, is race in Article 26.3? Who's looking at Article 26.3 here? Just say yes to me, please. Yes. Yes. You have a right, whatever your race, place of origin, political opinions, color, creed, sex? No. Well, rights are given in each one of those sections in Article 15. Now you move to Article 26, where you're telling people don't discriminate on the grounds of each one of these, and yet you leave out sex? Yes. Yep. That is the context in which this word is given. We're not talking about same-sex. We're talking about a series of rights that have been given in Article 15, in which the Constitution is saying don't discriminate against people on the ground of these particular rights. It is wrong to discriminate on those grounds. And therefore, the grounds are given. I gave them to you. You said back to me which ones were there. The one that is not there is sex. As a result, as I told you earlier, it has been claimed by international organizations, as well as ourselves, that we have failed to protect against discrimination persons on the ground of sex. Sex, there being male or female. It's only two, male or female. And we fail to protect them. So if you wish to take the argument further, I'm only placing mine. And we can go further if you wish. But that's a very simple way of looking at it. However, I'll go back. Could we go back now? Now that I put that into some of your ears, I want to go back to the major presentation, because I want to show the proposed amendment to Article 26. Thank you, ma'am. I do like to get a little bit of feedback. I've been told I've talked too long. We're almost there. We're almost there. Okay. The proposed amendment, 26.3. In this article, the expression discriminatory means affording different treatment to different persons attributable wholly or mainly to their respective descriptions by race, place of origin, political opinions, color, creed, or, and we ask that you insert sex, whereby persons of one such description are subjected to disabilities or restrictions to which persons of another such description are not made subject, or are accorded privileges or advantages which are not accorded to persons of another such description. Commentary, it amends Article 26.3 to add the word sex as a prohibited ground of discrimination, hence enshrines gender equality as a fundamental right. This is the context, and it's consistent with Article 15. It will likely entail consequential amendments of other laws, but that has to be done. And so we look at all of it, and we can look at the Matrimonial Causes Act. won't do it now, but if you wish in the discussion, I can show you a little bit about the Matrimonial Causes Act, that marriage in that act, section 21 says marriage is void on any of the following grounds. But that is taking us into another level of argument. So let's leave that. Oh, read section 21. Section 21 of the Matrimonial Causes Act, which says marriage is void on any of the following grounds. C, that the parties are not respectively male and female. That's our law. That is a part of our law. A void marriage does not exist. It does not ever exist. It cannot be recognized in law. That's what void means. There does not appear to be any cases in the Commonwealth where the inclusion of sex simpliciter as a ground of non-discrimination has led to a recognition of same-sex unions. Now, if it's been in our Constitution, in Article 15, for 41 years, and no one has raised an issue about whether that gives a right to same-sex marriages, it's there. We have rights. It's the fundamental rights. And it has sex. 41 years. Now, all of a sudden, if we put it in the discriminatory clause, we're raising up another issue, which we have a law that says no marriage is valid if X, Y, and Z. I rest. I'm sorry, I talked too long.
Thank you very much, Justice Nottage.